Okay, so I'm hoping it's going to be recorded and posted to the Western States Water Council's webpage at westernstateswater.org. Today's webinar is going to highlight revisions to the implementing regulations for Section 4 of the Endangered Species Act. We are going to hear from the key U.S. Fish and Wildlife about these revisions. Bridget Fahey, I hope I said her name correct. Bridget is the chief of the Division of Conservation and Classification at the U.S. Fish and Wildlife Service in Falls Church, Virginia. But before I turn it over to Bridget, I just wanted to let you know, taking questions at the end of this webinar. So if you do have some questions as we go along, you can use the chat to capture them and I will read them at the end. Otherwise, you do have the ability to unmute yourself and ask the question that way. So I'll repeat this at the end of the presentation, and now I'm going to turn it over to Bridget. Give me a minute and let me see if I can make that happen. Let's see. Share. Let me click Bridget. Change role center. Okay. As far as I can tell, it looks like I have handed this off to Bridget. So Bridget, does it look like you have, there you go, right on. Here we go. I think, Bridget, I can't hear you. Let me, okay, go ahead. I just turned off your mute.
Okay, I'm on the phone. Maybe that's the issue. Can you hear me now?
Yes.
Oh, great. So you can hear me. Can you see me and my slides?
Yes, we can.
Okay, great. I was going to see if I could figure out how to turn my video off so I'm not distracted by myself over here, but
I can probably help you with. Nope.
No problem. It's just that my PowerPoint's over here, my camera's over there, so it's going to have a funny view. But hello, everybody. Welcome to the webinar today. I'm going to talk about some ESA reg changes that we finalized last year, and I'm going to ask for your patience. I gave this presentation probably a dozen or so times last fall, but this is the first time I've been asked to give it in a while, and so it's the first time I'm giving it this year. So the changes that we made, we announced changes to 3 sections of the Act. I'm only going to talk about 2 of them because only 2 of them fall under my area of responsibility. But these changes were made with both the Fish and Wildlife Service and the National Marine Fisheries Service. So the secretaries of both Commerce and Interior share responsibilities for implementation of most of the provisions of the Endangered Species Act. So generally, marine species are under the jurisdiction of the Secretary of Commerce, and terrestrial species are under the jurisdiction of the Secretary of Interior. So the authority to administer the ESA has been delegated by the secretaries to the Fish and Wildlife Service and National Marine Fisheries Service. Okay, figured out how to advance the slide. So hopefully you guys are seeing the second slide. So the 2 areas where Fish and Wildlife Service made changes, where we made some changes that fall within my area of responsibilities, are to Section 4 of the Act. These are the regulations that 50 CFR 424. And those, so Section 4 of the Act, as you might know, covers a broad array of items, but the regulation changes that we made to Section 4 were specific to the procedures that we use to add and remove species from the federal lists of threatened and endangered wildlife and the procedures for designating critical habitat. Section 4 also talks about protective regulations for threatened species, so those are referred to as 4D rules. I'm getting a little bit of feedback, so I'm not sure if there's still folks on the phone or the computer that could maybe mute. And then Section 9 of the Act establishes the prohibitions for listed species, included endangered species and threatened species, and those implementing regulations are found at 50 CFR 17. Okay, so I'm going to talk a little bit of some background on how the revisions were made. They were a step-down implementation of an executive order aimed at reducing the regulatory burden on American citizens and promoting innovation. And individuals from both departments, the Department of Interior and Department of Commerce, at the high policy level, met with career staff from Fish and Wildlife Service and NIMS leadership with, I think we added up a couple hundred years of experience implementing the Endangered Species Act in December 2017. And we brainstormed a lot of ways that we could improve implementation of the Endangered Species Act. And at that time, we decided to focus first on Sections 4 and 7 of the Act.
Bridget, we've lost you. We can't hear you. Hold on. Yeah. Okay. It shows that you're not muted, so. Nope, still not hearing you. Shoot. What is going on? This is not good. Share, edit, mute, audio. Can you try talking again? I don't know what's going on. No. So on your screen, can you go to the audio and let's see, can you?
Hey, Beth, this is Otto. I think since she's using the phone, it's a separate, like it doesn't show on the screen. Maybe, I don't know if Bridget, if you can hear us, if you can maybe hang up and call again. Not sure what happened.
Okay. Sorry, guys. Let me see if I can take it back. Claim host. So Bridget, can you hear me? Oh, hold on. Okay, now try. Talk. No, shoot. Well, I'm not very impressed with WebEx. I don't know what to do.
Hey, Deb, she might be able to see the chat. If we can send her, I sent her a message.
Can you hear me now?
Yes.
Okay.
I don't know what was going on. Sorry.
Well, I just switched from the phone to the computer.
Okay, great.
So hopefully you can still hear me, or maybe you
Yes.
can hear me better.
Yes.
All right, where did I leave off with you? What was the last thing you heard me say?
I don't know. I was too panicked about the the audio.
Okay, well, I'll just really quickly then cover this slide that you've been now looking at for quite a while. We went through kind of a long process in making the revisions, but I think I have a little more detail about the timing on the next slide. So here's the timeline. We had an open federal register. I think most of the federal government did this in 2017, requesting public input on any regulatory reform initiatives. We got a lot of good ideas from members of the public and stakeholder groups. Not all of those were specific to the ESA, but we looked at all the ones that were specific to the ESA, reviewed those comments to get ideas on where stakeholders were wanting to see some improvements. We published some proposed rules in July of 2018. We had a 60-day comment period where I mentioned earlier we got hundreds of thousands of public comments, over 1 million if you include commenters that signed form letters. And then we published final rules in August 2019, and they became effective about a month later. I'm hearing a good bit of feedback. I don't know if everyone is, but if you're not speaking, maybe you could mute. So I've been muted? Okay. I'm going to give a overview of the changes that we made. We made 4 changes on the procedures for listing, delisting, and reclassifying species. I'm going to go through each one of these in more detail, but we created a regulatory framework for the phrase foreseeable future. I'll explain why that's important. We clarified the standards for listing and delisting are the same. We streamlined the factors considered in delisting, and we removed a provision barring reference to economic or other impacts in classification decisions. We also made 3 changes to the procedures for designating critical habitat. So we clarified when it's not prudent to designate critical habitat. We revised some of the process and standards for how we designate critical habitat, and we revised our definition of physical or biological features, which is a term of art from the Act itself. So here is our final regulatory framework for the foreseeable future. So, I'm not going to read it to you. You can read it yourself either now or maybe later if we can share the slides later. But I think the key operative sentence here is that the term foreseeable future extends only so far into the future as the services can reasonably determine that both the future threats and the species response to those threats are likely. So some key elements I kind of talked about. It's not just a matter of demonstrating the chances of a threat manifesting in the future, but the species response to those threats are likely. And actually, I should back up a step and tell you why the foreseeable future is so important. It comes from the definition in the Act for a threatened species. So an endangered species is a species that's in danger of extinction now, like right now. But a threatened species isn't in danger of extinction now, but we can look into the future and see that it's going to be in trouble with the information we have about what's likely to happen in the future, either continuing on threats or new threats that we can see on the horizon. So it's a really key element when we're determining if a species should be listed as threatened. So the key elements here is a species-specific analysis because it's really tied to how a species is likely to respond, and those species response are really tied to that species' biology and life history. So there's no one-size-fits-all. Every species is different, both in its own biology and natural history, but also different in the threats that it faces, its geographical distribution. We use the best available science to determine the timeframes for these threats manifesting and the species likely response. We don't need certainty. It's just likely, not certain, but it shouldn't be like speculative, right? So thinking like, well, if this happens and this other thing happens, and then get too far afield from what's likely to happen. And we don't have to define the foreseeable future in terms of a specific time frame if we don't have the data or information that would support that. So one real key here, I saw a lot of press, and maybe you guys all saw a lot of press. Some of the press that we got, I don't think was very flattering, and some, you know, I'm probably a little biased, I think was unfair. One of the things that people viewed this as a big change, and they viewed this, you know, change as being something that would remove our consideration of climate change, for example, as a threat. And that wasn't what we think we did, and that's not the intention, and it's not how we're using it. We didn't have any regulations that spoke to how we interpret foreseeable future, but we did put into place procedures and methods that we had been using for approximately a decade that is laid out in a solicitor's opinion that dates back to 2009. But we wanted to capture our procedures and regulation to provide transparency to the public, and of course regulation has got higher legal standards, and so get better consistency across the board. So just like any other threat, if we are considering climate change in determination of whether a species is threatened in the future, we look at the information we have about that threat manifesting and the information we have about the species' response. And when we can determine that that threat is likely in the future and the species is likely to respond to it in some way to the level that's in danger of extinction in the future, then just as always, it's a legitimate approach to determining a threatened species. So next one is the factors considered in delisting. So basically, I'm just kind of showing you the regulatory language. We should delist a species if it's extinct, if it doesn't meet the definition of an endangered or threatened species, and when we make that determination, we look at the same 5 factors that we look at for a listing determination. Or if the listed entity, we get new information about maybe the genetic makeup, or some new taxonomic papers are published that the listed entity no longer meets the definition of a species as it's defined in the Act, which is a species, subspecies, or DPS. So what changed? Well, we really thought it was important to clarify for the public that the standard for listing and delisting is the same, and that is the question of whether the species meets the Act's definitions of an endangered species or a threatened species. We also kind of streamlined and simplified the regulatory text. So just to crosswalk, the final regulation talks about extinction. That was in the previous reg. If a species is not endangered or threatened, that could be because it's recovered, or it could be that we receive new information. And if the species does not meet the definition of species under the Act anymore, that could be due to changes in taxonomy or some erroneous data. So why the change? So within the service, the Fish and Wildlife Service and the NIMS, we felt like we've known all along that these 2 ends of the Act are mirror images of each other. But we have a lot of case law where courts appear to have set a higher standard for delisting a species than we've ever had for listing a species. And so, you know, courts have asked us to demonstrate certainty about future regulatory mechanisms that seem to set a higher standard than we would have for listing. And so that was one of the motivators behind the change, and then just to tie the regulatory text more with the statute about when the best available information indicates a species should be delisted. The next change is probably one of the more controversial changes, and it's one again where I feel like some of the press on this got it a little wrong. We struck some language. You can see the finalized reg and the previous reg here all on one slide. So basically there was a statement in our previous regulations that the Secretary makes our determinations solely on the basis of the best available scientific and commercial information regarding a species status, without reference to possible economic or other impacts of a determination. And striking that economic language, in striking that, we did not mean to imply that we would consider the economic impacts of a listing determination when we make that determination. But we made the change to acknowledge that there might be circumstances where we want to present economic impacts of a listing. We might think that that's informative to the public, and we didn't want anyone to construe that regulation as preventing us from doing so. But just to be crystal clear, the requirement that we don't factor in economics into listing decisions in making the listing decision is in the Act itself. And so that's not something that can be changed through a reg. So just if information on economic impacts is compiled and presented to the public, it's for informational purposes in the interest of transparency. And we'll just need to be really careful to, if such information is compiled, which we haven't actually done yet for any of the listings, nor have I heard that NIMS has, we just have to be clear to wall that off from the decision itself. So moving on to the changes to critical habitat. The final regulation laid out 5 circumstances where we would determine that it's not prudent to designate critical habitat. So just for a little bit of background, the Act is pretty clear that we should designate critical habitat in most cases, and that we should designate it at the time of listing. But it does leave the door open for a not prudent determination when we can support that conclusion. So, so an example is if we publish maps and that could increase the threat to the species. So for example, if a species is threatened by taking, if it's something that's heavily collected, has high value to collectors, and if we tell everybody where it is, we're going to actually increase the threat. That's maybe the textbook case for a not prudent determination. But our regs also had an element that we could make so the point of critical habitat rate is to protect habitat, but if you have a species where habitat loss or modification under factor A isn't a threat, then in those cases, we find that it's not prudent to designate critical habitat. So we expanded that. That first element that I just talked about was already in the reg. This is like little I, but the yellow language is stuff that we added for this reg. So if the threats to a species habitat stem solely from causes that can't be addressed through a designation, so you know, critical habitat is a much maligned section of the Act, but it doesn't actually do anything if there isn't a federal nexus and federal activities going on, right? So most of the protections that a species gets comes from it being listed in the first place and having the prohibition against take of it. And so critical habitat designations add an additional layer when you're in Section 7 consultation that federal action agencies have to make sure not only do they not jeopardize the species, but they also don't adversely modify critical habitat. And if the threats to the species habitat are something that's beyond the ability of those federal land managers or action agencies to address, then it wouldn't make sense to designate critical habitat. And the example I'll give here is we listed these 2 stoneflies in Montana, known from Glacier National Park. They rely on melting glacial meltwater. That's where they breed. And the glaciers, as you might know, in Glacier National Park are going to be largely gone. I think it's predicted in the 2030, 2040 timeframe. And there's really nothing that the Park Service is going to be able to do in that case to stop the glaciers from melting. The forces that are causing the glaciers to melt are beyond the ability of that local unit to make a difference there. And so having a designation of critical habitat there wouldn't really be helpful. Those consultations wouldn't be helpful in addressing the one threat that the species was listed based on. We also have a provision to make a not prudent determination when the United States provides little to no conservation value for a species that occurs primarily outside of the jurisdiction of the United States. So these are species that are maybe mostly in Canada or Mexico and just like dip into the United States, but we might only have a big sliver and we're a little sliver, and the conservation for that species is really relying on that, Mexico or Canada to conserve the species. And we can't designate critical habitat in other countries. So that's where we'd say, the juice is not worth the squeeze here for a designation. We don't think it's prudent. Also, if we can't find any areas that meet our definition, there's a pretty strict statutory definition for critical habitat, and if it can't be met, we wouldn't designate critical habitat. And then the last one, number 5, is just kind of a catch-all. So what changed? That first one on the increased degree of threat, nothing changed there. For the, we used to have a rationale that a designation of critical habitat would not be beneficial, and we removed that rationale. We found ourselves arguing a lot in court about whether a designation is beneficial or not, and we had a different view than some of our folks on the other side of the litigation table as to the benefits of critical habitat. And we decided if we took out that no benefit approach, then we can go straight to fact patterns that support a not prudent and not have to have difference in viewpoints on the benefits of critical habitat. And then we added, so we retained a couple of the old lines of rationale, and we added 2 additional circumstances on when you can't address the habitat-based threats and when U.S. jurisdictions provide negligible conservation. Although I will say that the last regulations did talk about that issue in the preamble as a reason to get to not prudent, so we thought it was more transparent to pull that down and put it in the regulatory text just to be crystal clear. So I think I actually addressed all these points. So I'll move on to the procedures for designating unoccupied critical habitat. It's kind of hard to show a before and after here, so I tried to get it all on one slide. But here's sort of a strikeout underlying version of the changes that we made. But I'll just go straight to what changed. We've gone back to a sequential process for designating critical habitat. So we had changed our regulations in 2016. And pre-2016, we always looked at occupied critical habitat first before moving to unoccupied. In 2016, we changed the regs to be more holistic and say, we'll look at the big picture and we'll have some occupied and some unoccupied based on what makes sense. That wasn't popular with a lot of the stakeholders. We were getting sued on it, and so we decided to go back to the sequential approach where we look at occupied critical habitat first before moving on to unoccupied. So we'll always evaluate those occupied areas, and if they're not adequate for the conservation of the species, then we can consider unoccupied habitat in addition. But those unoccupied areas must both, with reasonable certainty, they must both contribute to the conservation of the species and contain one or more of the essential physical and biological features. So why the change? It was a policy decision to go back to our former sequential approach due to concerns raised by our stakeholders. We also had that Supreme Court ruling in the Weyerhaeuser case that where the Supreme Court found that critical habitat must first be habitat. And so by adding the requirement that unoccupied areas must have one or more of the physical or biological features essential for the conservation of the species, we thought that we were ensuring that we wouldn't designate anything that didn't qualify as habitat under the unoccupied habitat prong. And then the reasonable certainty standard was added to address that same case about whether, so that we could factor in the likelihood of unoccupied critical habitat and contributing to conservation. So if there's no likelihood that an area is going to be able to contribute to conservation, maybe it's not restorable, maybe it's too far gone, maybe there's no reasonable way for it to contribute, then we won't be designating it as critical habitat. We made just real minor changes to our definition of physical or biological features to just clarify, make it crystal clear that those features are the features that are essential to the conservation of the species, and they need to occur in specific areas that are essential to the species. We made that change because we got that issue came up in public comment, and people wanted us to make that more specific. Okay, so that is it for the 424 reg. I'm going to go now and talk about the changes we made to 4D rules, and those apply to 50 CFR Part 17. I'm also going to say, I mentioned earlier that both Fish and Wildlife Service and NIMS implement this act together, but this part of the regulation was Fish and Wildlife Service only, because the Fish and Wildlife Service, so just to give you a little background, I know like I go deep in ESA wonkiness, but the background is that in the act itself, Congress gave a bunch of protections directly to endangered species. So the take prohibition, import, export, all the prohibitions that you would read in Section 9 of the Act. For threatened species, though, they basically said, you know, Fish and Wildlife Service and NIMS, we're going to leave it up to you to decide what makes sense to put into place for that threatened species. So you could put in all of the prohibitions or none of the prohibitions or some of the prohibitions, just, you know, do something that's necessary and advisable for the conservation. That's what the Act said. And then back in the 70s and 80s, the Fish and Wildlife Service decided that it would be easier and simpler for threatened species to automatically put in all the protections of endangered species. And so we did what was called a blanket 4D rule. We did one for plants, we did one for animals. We revised them a little in the first decade or so of having them. So basically, it gave threatened species all the protections of endangered species. But we've started doing a lot more species-specific 4D rules, and we saw some benefits of doing so. And so we rescinded those blanket rules that automatically apply all those endangered protections to threatened species. And so moving on from here forward, anytime we list a species as threatened, we're going to make a determination on what protections they get on a case-by-case basis, tailored to what that species needs to protect it from becoming endangered in the future and to allow it to recover. And because the National Marine Fisheries Service never put into effect those blanket rules, this was something that was Fish and Wildlife Service only. So now we're more similar to what the National Marine Fisheries Service does. If they're going to put into protections for threatened species, they've always done it on a case-by-case basis. Just to clarify, though, we're not, the species that were already listed in the past, things that were listed as threatened already in the past, where we invoked the blanket rules, they still have the same protections. So this didn't undo any of the protections for species already listed as threatened. And if we want to change those protections, we'll have to do a species-specific rule to replace the protections they get. So here are the why is, you know, sometimes we can see a lot of benefits from doing a 4D rule. You really focus on the protections that the species needs, and you don't catch up in sort of this regulatory net or permitting net, sort of de minimis take where it's not necessary for the conservation to regulate those forms of take. We can remove some redundant permitting requirements. You know, some states have their own endangered species laws and their own permitting requirements, and so folks have to go both to the state and us. If we feel like the state's regulatory scheme is sufficient, we can maybe adopt theirs or refer to theirs through our rules. Just to be clear, it doesn't remove the requirements for Section 7. If you have forms of take that aren't prohibited by a 4D rule, you still will have to consult on them. Section 7 is an independent authority and requirement under the Act, but it certainly can streamline those discussions where we've said something is not an issue for the conservation such that it doesn't need to be prohibited by a 4D rule. It should make that consultation simpler, right? By saying these actions are compatible with the conservation in a 4D rule, in the future, we should never be getting to a point where they would result in jeopardy. We also use them to facilitate beneficial conservation actions. So we use them where maybe to streamline restoration, allow restoration, and really incentivize good things happening. And then by focusing on the big ticket stressors, we can make the best use of our not just our limited resources within the agencies, but the limited resources of the regulated community too. We'll focus on the things that are the big issues. So that's it for all the material that I was going to cover. And I understand we have some time for questions. If you've got some questions for me, I would be happy to answer them.
So just as a reminder, you are in control of being able to unmute yourself to ask a question. Otherwise, you can use the chat and I'll read those questions aloud. Anyone?
Maybe I'll start with a question for you all, a little quiz. I'm just always curious because I think that we did get a lot of press on this and it wasn't that flattering. I'm curious if anyone came across that and had some questions about it or concerns. If there's anything I've said today that's been helpful in that regard, or if you guys have any feedback for us.
So I'm wondering, maybe people can't unmute themselves. Let me see here. Okay, so I've just unmuted the list in case you all are having issues with that. So are there any questions now? No?
Okay, I see a question on the chat. Have we seen or anticipate these changes having negative impacts or keep things similar? You know, I think for a large degree, they kind of codified stuff that we had been doing for a while, say an example of foreseeable future or an review to delisting. So for us, it was just an issue of sort of transparency and maybe getting a little bit more of a foothold when it came to some of the litigation we see. You know, I think that in the rules that I've been reviewing that come through that use these regulations, I feel like they do a really good job of focusing conservation both through the 4D rules, but also through the critical habitat designations. So I don't want to say that they haven't made any changes, but I think that the changes kind of tightened up our rules and helped us tell the story of what areas we need for conservation and why, and what protections we need for threatened species and why.
Okay. Are you seeing any other questions? I didn't see that question come through. I'm sorry. I, for some reason, couldn't see it.
Hey,
I guess perhaps we're good.
well, I hope everybody is staying safe and staying healthy and adjusting to this brave new world that we've been experiencing.
Well, I really appreciate you taking the time today, Bridget, for your presentation. And I guess that concludes today's webinar. So have a great week and everyone stay safe. Thanks so much.
Bye, everyone.
Bye. I'm really surprised that